Imagine a future where oil and gas entities are developing geothermal projects at the scale they currently drill wells for oil and gas. Tens of thousands of projects per year globally, providing terawatts of clean baseload to the grid. Heat has become a significant player in the world's energy mix, a valued and essential asset, just as oil and gas molecules had been in the past century. This future raises a novel legal question about the future of geothermal energy. Who owns heat? The oil and gas industry has operated over the past decades, relying on a century of regulatory evolution and legal jurisprudence, both well developed in many parts of the world. This regulatory and legal foundation mitigates risk and creates certainty with respect to what entities can expect when developing oil and gas projects. But in most places in the world, geothermal is sufficiently different from oil and gas development as to not benefit directly from this history of regulatory and legal development. As new, scalable geothermal concepts emerge and make development of the resource feasible in places it had not been prior, a new frontier has emerged that lags behind in regulatory and legal development. And as a result, geothermal developers are facing legal and regulatory uncertainty. So, what types of questions arise when considering who owns heat in the subsurface? What is the balance between surface and mineral right owners? And what steps can entities and jurisdictions take to clarify these issues and reduce uncertainty for entities pursuing geothermal development? Let's explore.
Hello, everyone. First, I want to thank Jamie Beard for the incredible job and hard work that she has done and is doing to conceive, pull together, and produce this conference. Fantastic, great job, and I appreciate being asked to participate. Texas is the energy capital of the world and the oil and gas capital of the world. In Texas, we have probably the most well-developed jurisprudence regarding oil and gas real property law in the United States. We know all about the mineral estate and the surface estate, but what about the geothermal estate? Is there such a thing? Who owns the heat? Is it part of the mineral estate, the surface estate, or something different and unique as other jurisdictions, other states in our country call it sui generis, which, as you probably know, means of its own kind. To discuss this question, we have a superlative panel made up of some of the very best legal minds in Texas on this subject. They are all equally outstanding, so I'll just mention their names alphabetically and then let them introduce themselves in a moment. We have Professor Gabriel Eckstein, Professor of Law and Director of the Energy, Environmental, and Natural Resources Systems Law Program at Texas A&M School of Law. Peter Hosey from Jackson and Walker, Nicholas Miller from Graves Dougherty, and Mike Tomsu from Vinson and Elkins. They are all first and foremost in their field being energy lawyers, oil and gas lawyers, land lawyers, natural resource lawyers, and an energy professor. I'll start it off by introducing myself, and then I'll turn it over to each of them. For the record, my name is Ben Sebree. Formerly, I was Vice President for Governmental Affairs and General Counsel for the Texas Oil and Gas Association. In private practice, I represent businesses and various trade associations at the Capitol in Austin, attempting to craft responsible energy, oil and gas, water, and environmental policy. So yes, that means in addition to being a lawyer, I'm also a lobbyist. But don't worry, I don't sell used cars or insurance. Among other things, I'm involved in geothermal energy policy at the Capitol in Austin. This is a really exciting field, and I'm proud and excited to represent SAGE Geosystems as well as the Texas Geothermal Energy Alliance. I also represent oil and gas companies, water recycling companies, and environmental solution companies. On a personal note, I've been involved my entire career in the energy policy field, and I'm absolutely thrilled that we're now on the cusp of being able to drill for, capture, and produce heat into a sustainable baseload, virtually limitless and carbon-free source of energy. So for all of you who are actually doing that, who are tuned in now, thank you so much and Godspeed. Accordingly, the time has come when it's necessary that we all try to help the law and the policy makers answer the question, who owns the heat? So I'll turn it over to our first panelist to introduce himself and then each of them, and then we'll dive into the discussion. So Professor Eckstein.
Thank you, Ben. So yes, I'm professor at Texas A&M and have been here for more than a decade. I direct our Energy, Environmental, Natural Resource Systems Law program, which we affectionately like to say includes everything under the sun. We do deal with all sorts of issues, whether it's land use, energy resources, alternative energy resources, environmental, water, and so on. I've been doing a lot of water issues, groundwater, especially globally, not just here in Texas, throughout the U.S., but globally, dealing with legal issues, policy issues, management issues, in particular in a transboundary context. And a lot of that has been based on the fact that I also have a geology degree, which has really helped me get a better sense of sort of the science to policy to law relationships, the interface, and how do we write better laws and better regulations that are based on sound science. And this is what I'm really excited about, in this geoenergy space, that the science is evolving as we speak every day. And I am excited about it, in part because I understand it, just because I have some of the geology background, but I can see it evolve in front of me, and I am excited to be a part of this particular panel dealing with this issue of ownership of geothermal resources and the heat in particular.
Cool, thank you. Peter.
Yes, good afternoon. My name is Peter Hosey. I am a partner in the law firm of Jackson Walker, and as Ben said, Texas is the hotbed of energy. In fact, our firm, rather large, is headquartered here in Texas and has all of its offices here in Texas. I also teach Texas land titles at St. Mary's University School of Law here in San Antonio, and I'm a member of the State Bar of Texas Title Examination Standards Commission, which writes the title examination standards in the Texas Property Code. They're not standards in the sense that we say, here's what you have to do and have to meet these requirements. It's more in the nature of what you see in the Midwest and other states, title standards, which are basically our commission's opinion of the status of the law with regard to those subjects pertaining to real property matters that we publish. I've been involved in energy my whole career, over 40 years, originally out of law school with Exxon, and then in private practice. I've been chair of the energy section of the State Bar. And so what I found very exciting recently, as we've obviously over the last decades evolved from just oil and gas into many more energy types. We lead the nation in renewables. And so we're dealing with this issue not as to what is it, who owns it, not only, believe it or not, in geothermal, but in renewables. Even though we lead the nation in renewable, we have never had guidance from our Supreme Court as to exactly what is it. Is it severable? How do you treat it? We're also dealing with that in terms of produced water pursuant to hydrofracking operations, and now in terms of geothermal. And as we have learned in the hard way the last several years about the shortfall in energy when we need it, we're thirsting all over the world, in particular here in Texas, for new sources of energy, geothermal being one of them. And then, of course, it begs the question, how do we explain to the engineers and the financiers and business people what the legal significance of what they're tapping really means. And so I'm very excited to be here with all these bright minds to find out and explore, perhaps help define what in fact that means.
Thank you, Peter. And by the time we get to the end of the discussion, I hope each of you will attempt to give a short elevator speech about what kind of guidance you give to those operators and who they should lease to. Nicholas,
yes,
please introduce yourself.
You bet. My name is Nicholas Miller. I'm a partner or shareholder at Graves, Dougherty, Hearon, and Moody in Austin, Texas. I've been here for about 10 years. Prior to going back to law school at the University of Texas, I clerked the Energy Resources Committee, as well as the Oilfield Cleanup Fund Advisory Committee, which we had under our purview. A little bit of background about me. I'm from West Texas ranching family near Amarillo. Was raised around the oil and gas industry and ranching on the surface side. My practice here is primarily representing land and mineral owners, as opposed to on the operator or industry side. I do almost all transactional work. However, I help out our litigators whenever we have oil and gas matters. We do a lot of oil and gas litigation as well. We've had a number of cases go up to the Supreme Court and Texas Supreme Court, creating new law in various aspects of oil and gas and mineral law, and also involved over at the Railroad Commission and in regulatory hearings. In the Railroad Commission, for those of you who don't know, is the governing body for energy here in Texas, even though it really doesn't have anything to do with railroads anymore. So that's my background, and I'm excited to be here. And I'm relatively new to the geothermal space, as most people in Texas are. And but it's exciting, and I've enjoyed learning more about it, and look forward to visiting about it today.
Thanks, Nicholas. And like you say, we're all new to this space, but each of you has a great deal of background and experience regarding the mineral space or the land space. And I think that's where we really need to dive into. Mike, you're next.
Thanks, Ben. My name is Mike Tomsu. I'm a partner at Vinson and Elkins, and I've spent the last 35 plus years working on issues that relate to the development and regulation of utility infrastructure, whether it be electricity, water, oil and gas, telecommunications. So I have seen dramatic changes in both technology and regulation through those many decades, and am fascinated and intrigued by the introduction of new technologies and advancing, maturing technologies. So we have had significant work in over the last 15 to 20 years. My focus on the electric side has been in the renewable space, wind, solar, energy storage, all things energy transmission, transition. And what I've found through that time period is that the law and the regulatory policy always tend to sort of lag behind the technology advances. And so I spend a fair amount of my practice, whether it's at the legislature or at the regulatory agencies, trying to help shape the regulations and help shape the law so that it reflects an ability to advance and utilize new technology. So glad to be here. I also teach wind and solar law at the UT Law School and look at these things from an academic side from time to time, but I'm here more on a practical side today and look forward to the discussion.
Thanks, Mike. Thanks, all of you. Let's dive into it. So our question is, who owns the heat? Is there a clear answer in Texas law, or maybe a not so clear answer that gives us guidance? Anyone want to take a first stab at it? Peter, Gabe, Nicholas, Mike?
Well, I think I'll take a stab. The answer to your question, in my opinion, is there's no clear guidance, which isn't unusual. We don't have clear guidance with regard to renewables either. And so we find that the industries prosper without it, and that Scriveners, Nicholas and I, end up preparing documents that are sort of kitchen sink type, in other words, incorporating a variety of concepts. But one of these days, it's going to be clear that a case is going to come along in which there's a dispute between a mineral owner and a surface owner as to the chain of title. And then the court is going to have to tell us what that means. And historically, in terms of other attributes, say renewables or oil and gas, it is a dispute generally between the mineral title owner, where minerals are severed from the surface, and the surface owner. And so if you read cases in other states, they have different definitions. I think in Texas, and please correct me, we look at the surface estate as sort of the entirety, save minerals in place. The pore spaces are surface. What we historically believe in the ordinary meaning of surface, gravel, that sort of thing is surface. We've had historically hiccups about substances that are generally thought of as mineral, but they destroyed the surface. We have somewhat gotten over that in the last 40 years. And then the minerals in place, of course, hydrocarbons or other type, uranium, coal, lignite, are mineral. What we're talking about here is somewhat less tangible. In other words, it is a force, an intangible force, the effect of which, it's the consequence of which that creates the value, the harvesting of which creates the value by turning that energy into electricity. And so the question is it going to be defined in terms of once it's harvested? Is it defined in place? These are some of the issues, I think, besides what will it be, but how will it be determined that we need to explore.
I'd like to, if I can pick up on something Peter was saying, I think one of the problems, one of the challenges we're going to have is in the way we've developed the law. I think Mike may have talked about lagging behind the science, behind the technology. We've developed the law in that fashion, and many of these jurisdictions we've defined the geothermal resources, and we've said, okay, they belong to the surface or to the subsurface estate, and we've given some kind of definition for geothermal resources. But if you think about what is geothermal resources, because what Peter just ended up talking about was the heat. Well, the heat is only one component of these geothermal resources. We have heat, we have water, we have dissolved particles, minerals that are in that water. We have the formation. And I think that to some extent, we have complicated the situation when we gave a definition for geothermal resources in a particular state like Texas or another state, when now we have to think about, well, okay, there's water in that geothermal resource, but what about groundwater law? There are minerals. You can even file oil and gas in some of these geothermal resources. Well, what about oil and gas law and ownership? And we're going to have some overlapping and conflicting claims because, in my opinion, because we've tried to define geothermal resources as opposed to separating all that out and saying, well, as the title of this panel, who owns the heat? And the heat, I think, needs to be separately considered from the water at whatever temperature the water is, the minerals in that water, the minerals in the formation itself, and so on. So I think that's something that we as a community need to think about, and certainly the legislatures need to think about.
And to add to that,
hang on, Nicholas, are you making a distinction between the rock, the water, and the heat being a property of the rock and the water?
I am. I think that's a good point, that heat is not a mineral in and of itself. Of course, a legislature can just legislate the definition, but as a practical matter, coal and gas and oil and water. Those are things that are tangible, things that you can touch. And from the basic understanding of what a mineral is, okay, some of that are minerals, but heat is a characteristic. Is
heat a mineral?
I'm sorry?
Is heat a mineral?
In my opinion, it's not. It's something unique. It's something different. And it's just like, a couple of you mentioned solar state, solar and wind alternative energy. I mean, wind is not a mineral. Solar energy is not a mineral. And we're trying to wrestle with, well, do they belong to the surface estate, or are they part of the mineral estate? Are they something unique? Where do they fall in? I think it's sort of the same idea in that they're characteristics and properties that we just haven't quite figured out how to characterize in the law. But I don't think any of them are minerals.
Nicholas, you were ready to say something.
I was. I wanted to add just a little bit what he was saying. And I kind of think of heat as he referred to it as a characteristic, but I think of it as a product. And it kind of depends upon the process in which it's created. I mean, if it's created from native waters and we're capturing that steam, and really that's all we're doing is capturing the steam off of hot water coming out of the ground, that's one thing. If we are talking about injecting water onto a hot rock, which then creates steam, and then we harvest that, that's another process. Or it can also come up, geothermal liquids can come up out of the ground as a byproduct of a hydrocarbon stream in an oil and gas well. And so that can be a third method. And each of those kind of has its own difficulty when we're trying to put it into a bucket, either the mineral side or the surface side. I tend to come down on the surface side because I think of, you mentioned pore space a minute ago, Ben, and I think of that geologic structure underneath the ground as similar to the rock under the ground. And then, as we know, is groundwater is owned by the surface owner, which is settled Texas law under the Day case many years ago, or about 10 or 12 years ago. So the groundwater is indisputably owned by the surface owner. So whenever we deal with the process dealing with those things, I think that the resulting heat is probably owned by a lessee due to the fact of a lease existing as between a surface owner and whoever wants to go in there and do their operation. I think of it as analogous, especially in that injection well example I gave. An injection well, when you're talking about pore space in a traditional disposal or injection well, that's governed by the surface owner. The surface owner is the one who would benefit from that or receive a royalty from if they've made a deal with a saltwater disposal well operator. And I think of it in terms similar to those terms, where the rock underneath the ground is owned by the surface owner. The water underneath the ground is owned by the surface owner. In the process creates the heat, which is then owned by the lessee, because they're the ones actually creating it. It's almost like a factory. If you rent out a factory, whoever's going to go in there and operate the factory will create their product, and they'll own that product, but they have to pay you for the right to go in there and operate. It becomes a little bit more difficult when we talk about a byproduct of an oil and gas stream or a hydrocarbon stream from an oil and gas well. Right now in Texas, where we haven't answered the question whether produced water is the same as groundwater, if that's owned by the surface owner or owned by the mineral owner or owned by the lessee, because traditionally that was a waste stream. But now that that's being monetized, we're fighting over the ownership of that. There's a case out in West Texas right now, Cactus versus COG, which my firm is involved in, that's made it up to the appellate courts, where we're seeking to answer that question. We're representing the surface owner, and we say we have a claim to that produced water. Well, I think that this is analogous to that, because if there's a byproduct coming up with the oil and gas or hydrocarbon stream that contains geothermal fluids or brines, then that would follow that logic that would also be owned by the surface owner. And could be dealt with accordingly.
What kinds of questions? Go ahead, Peter.
Well, I was just going to say there's another correlation here. Back in the late 70s, 77, the legislature came up with the Texas Geothermal Act. Long before we got into this produced water issue that Nicholas is talking about, and there's language in there that tracks conservation and waste, which are the prime directives with regard to the Railroad Commission's regulatory governance. But it also has other language, and some people argue that, well, the legislature saying that geothermal's minerals? Well, it's akin to what we're talking about in this produced water issue. There's legislation, and Ben, we were talking earlier about being involved in that recently, where the legislature again has attempted to say, if it's produced water, here's the definition of produced water, and it belongs to the mineral lessee out of the wellbore stream. But in either case, I think there's a question the legislature having the authority to basically alter vested property rights. If the water belongs to the surface owner or the geothermal belongs to the surface owner, the legislature, I think, is not the party basically to attribute those rights to someone else. And these cases like Nicholas is talking about are going to sort that out as we're dealing with produced water. The analogy is here to geothermal. And so then the question is going to be at some point, who owns that? I agree with Gabriel that it is an intangible. It is basically a value once harvested. If it is in the nature of what the technology is, if it's virgin groundwater, that's the source of heat. Well, whether it's solid, liquid, or gas, if the water belongs to the surface owner, it belongs to the surface owner. If some third party is injecting water of their own ownership into rocks that are hot, then as Nicholas says, that lessee would have ownership. But the important question is the lessor would be whom? It seems to me it'd be the surface owner, because that's who would own this rock pore space, if you will. And we keep getting around to all of these issues the same way. We don't have the answer, but we can analogize to other substances or take it from what the current law is with regard to the ownership of, say, water or other types of substances. And here in Texas, unlike other states, the definition of the surface, if you will, is different. It's more broad and in effect encompasses all ownership interests, basically, I think, save minerals in place. And having said that, then I think the surface owner would have a good argument, depending upon the way the heat is monetized, that would be require the imprimatur of the surface owner then for the lessee to be able to engage in that activity.
I got two questions. Taking from what the three of you have just said, and Mike, I want you to dive in here when you want to. But to summarize what I think I've heard the three of you say is that in Texas, we begin with the idea that the owner of the land owns everything. And then, as Peter said, you take away minerals, and you have a mineral estate and the surface estate. Minerals, and the surface owns everything except for those minerals. And then I've heard Professor Gabriel say, but heat is not a mineral. So if the owner owns everything, you take away the minerals, and heat is not a mineral, ergo, do we reach the conclusion heat belongs to the surface estate? Or is it that simple?
I don't think it's that simple. I think there's an opportunity here. Peter and I may disagree about whether the right place to do this is in the courthouse or the legislature, but I think we've got a 50-year-old statute that has some fuzzy words in it that says geothermal resources should be treated as mineral resources. But I'm not sure that really is intended to say anything about the ownership of the heat. And so I think there's an opportunity for the legislature to step in. I mean, recognizing that you can create additional court cases, but I think there's an opportunity for the legislature to step in and do some clarification about the ownership of the heat. I tend to agree with Gabriel that, heat is a physical property, and that the vehicle on which that heat is transported should govern sort of how you look at the heat and who actually owns the energy. So if the groundwater is owned by the surface owner and the groundwater is being extracted to produce the energy, the surface owner would own that related heat. But I think you have an opportunity with the legislature coming back in 2023 to try to clarify some of this, recognizing that the future is fraught with peril, but where we are now, when I think about this, legal uncertainty does not help when you're trying to attract capital in a growing industry.
Yes, sir.
And so the ability of us to clarify anything that can bring to bear on that issue so that the folks who want to invest in the newest and greatest and latest technologies can understand. And let me say, all of it can be fixed by clear drafting. But the baseline, if we can clarify that and eliminate some of the legal uncertainty, maybe a little bit, maybe you attract some of that capital that we're looking for to give that geothermal industry the kickstart that it deserves.
Yeah,
well said, Mike.
Ben, Ben, I don't mean to interrupt. I just want to say, I don't think it's a binary choice, as you were saying either, in that it's real property. Does it belong to the mineral or surface owner? Another possibility is it not real property at all? It's personality, just like oil and gas at the surface. And then we're not talking about the surface mineral owner paradigm necessarily. So I think Mike's right. Perhaps there's a role for the legislature to play here.
Oh, Peter, I think that's kind of a little bit what
Nicholas
I was saying. Yeah, go ahead.
Nicholas, I wanted to clarify something Mike said, and then I want you and Gabriel to answer that question. But Mike said something interesting, and for the audience, I want to clarify. He referenced a provision that's in Texas law, the Natural Resources Code, that was passed back in the 70s during the energy crisis and the oil embargo. But in the Texas law, as Mike said, it says, the legislature says that they want geothermal energy and associated resources to be developed as a mineral. But it does not say that it is a mineral. And for the audience, that's important. There is a provision in the law. They want the Railroad Commission to develop it with the similar types of regulations as oil and gas. But the legislature in the very next paragraph was very clear to say, even though we want it developed as a mineral, we are not stepping into the argument about who owns it. But Nicholas, you step into the argument about who owns it. Was it as simple as I phrased it, or is it more complicated like Peter and Mike said?
Well, it's certainly more complicated, and I think that the legislature probably recognized that back in the 70s, which is why they punted on the issue. They're also probably trying to avoid some sort of takings claim, because if I definitively say it belongs to the surface owner or it belongs to the mineral owner, it would open up that statute to a challenge through the court system that could be a takings. If I own something on August 31st and the law goes into effect September 1st, which strips me of that ownership just by definition, because the law says I don't own this anymore, I used to, or maybe I used to, but maybe we don't know the answer to that. I think that that's ripe for challenge. And I was kind of curious. So when Mike was talking about the legislature, I was kind of thinking to myself, wondering about how you would go about crafting that kind of legislation. Would that be another independent statute, or would you go back and modify that 1977 statute to take out that word mineral, or just to clarify what that means? And how it, I'm just kind of curious what your thoughts are on that. That's just something that just occurred to me, how that actually would look in a statute book.
Yeah, I think that's more additional language than it is changing language. I think that's the core problem here, is that there's a gap, and I think you cure that with additional words. I think what we've seen in wind and solar is it may not be a perfect system. You may not get every gap closed, but you will then sort of generate the court cases that can work around specific better words to do some interpretation. So I agree that with Peter that there's not a binary. I mean, there's not a solitary answer. One answer here. I think there are multiple answers here, but I think there is significant room to improve on that statute with the collective brain trust that is interested in this issue and could bring to bear on it, recognizing that you may still perfectly end up where you think the words are perfectly clear, as often happens on a contract, that you end up in the courthouse looking for someone to give you the correct interpretation of those words in the statute. or in the
Well, as
contract.
I recall, I think it was the legislature in 2011, and Nicholas, I believe you were involved in this. But at the same time, the Day case was working its way up through the courts. And for the audience, that's the case Nicholas referenced that from our Supreme Court established once and for all that groundwater is owned by the surface estate. But in 2011, the legislature stepped in and passed a law that essentially was a really strong opinion that said the legislature recognizes that groundwater is and always has been owned by the surface estate. I think to your point about takings, if that was untrue, if it was owned by the mineral estate or someone else, they didn't have the power to take it. But they stepped in and said, we, the legislature, are putting down our heavy foot and saying we believe it's owned by the surface estate. So maybe they could do the same thing with geothermal. But Gabriel, we didn't give you a chance to answer the question that we've been kicking around. If it's not a mineral, does that mean it's owned by the surface estate, or is it more complicated?
Well, maybe I can complicate it further. I wonder if you need to own it. And I'll give you the example because think about solar energy. You as a landowner, do you own the solar energy that is falling over your land? It's kind of awkward. Same thing with wind. I mean, do you own the wind that is flowing across your land? So in the same vein, I have to question, can you really own the heat that is underneath your property? And, you can own the product, as Nicholas said, but I'm not sure I agree with his definition of what the product is. I don't think the heat is the product. I think it is the steam or the BTU or the whatever the electricity that is generated from that heat. In the same way that it's with solar energy, you're capturing solar energy on these solar arrays, and you're converting them into that electricity. So the electricity there becomes the product, but the actual solar energy, I don't know if we should make it ownable until captured. In many respects, when we really haven't quite defined solar estate and wind estates, I think in almost any jurisdiction, but we're talking about access. We're not talking about ownership. We're talking about giving a lessee or a somebody, a third party to come onto your land to access that solar energy or access that wind. Not that you own it. It just happens to be you have the exclusive territorial right because it's over your property, and you're just letting somebody come onto your property to capture it. Once it's captured, converted to energy, now you've got the product, now you've got ownership rights in something. But you never had, in my mind, ownership of that wind or that solar energy. In the same way, I can see us treating heat underground. I'm worried about the unintended consequences that may come out of imposing ownership on heat underground or solar energy or wind or any of these other characteristics. Things that we just haven't thought about yet. I think what these companies really need, they need access and the opportunity to convert it to energy. Why do we need to mess with actual ownership?
Yeah, I think that to add to that, I think that's right, and I agree with that. And I think that the title "Who Owns Heat" may be a bit of a misnomer, because what you're talking about is, you're that characteristic, or that it could almost be that energy created from that heat or that steam, as Peter alluded to earlier. Like oil and gas, when it's produced, becomes personal property. I think that probably is more akin to personal property. And you suggested access being the key. Whenever you own the land, so when somebody wants to come put solar panels on your surface, then you lease them that right. you own the land. When somebody wants to come put a wind turbine on your land, and you lease them that right, you're not necessarily leasing them the right to use that wind, you're leasing them the right to use that land. And I think that that's similar in that you're leasing them the right to use the underground formations, the underground heat, be it a hot rock, be it native water that's already hot or produced along with hydrocarbons. And I think that that's more of a process issue and more of an access issue, as you said, and more akin to the surface ownership, because there's not, the heat is what's created, and that's where, like, a personal product owned by the lessee, I think.
Yes, but the question is, Peter, I think you might have, I'm sorry, I was talking over you. I've got a question for all of you, and Peter, you might have kind of addressed this, but as we were developing wind and solar, were there ever any fights, arguments, legal cases about who owns the wind or the wind energy or the solar energy? Were there any fight? And if so, what can we learn from it? And if not, why does it matter for geothermal?
Well, I think it fits into what Nicholas and Gabriel were saying, and that is the heat itself. Perhaps our issue nomenclature, who owns the heat, is somewhat misplaced. Maybe nobody owns the heat. The question is, okay, from whom do you acquire the authority to come on the land and harvest that heat? And in Texas, if basically the mineral estate is minerals in place, then it would seem to me the answer would be the surface owner. And so I think we answer it in that sense. Who is the party who is required to provide the authority to the lessee to come onto the property, so that, as Nicholas says, that lessee will then own the product of that harvested energy that now can be monetized. In answer to Ben's question, yes, there are cases in other states that deal with renewables and a fight over who owns what and who should give that authority. We have an older 20th century case in which a landowner sued a railroad company that had put up a big earthen embankment that affected the wind flow to his windmill. The court didn't really get into who owns the wind. And as Gabriel said, what is wind? It's a reaction in the atmosphere to pressure change. What is solar? It's ultraviolet. You don't really own it. It's not really tangible as such. But from whom then would you acquire the authority to be able to exploit that subsequently harvested, monetized phenomenon? We've had some recent correlative rights, a recent West Texas correlative rights case over solar panels and oil and gas operators, and this sort of accommodation doctrine race to see who develops first. And the court said, well, you, the oil and gas estate owner, can't get an injunction to keep the solar panel lessee from ever developing, because someday you might want to engage in oil and gas development. So unlike the footprint for wind, which is similar to oil and gas, it's not dispositive. Solar is. You put up a solar farm, there's nearly no other purpose for the surface. But the court said, fine, once the solar farm is up, that's it, and you can't put in your oil and gas. So these kind of disputes or ownership disputes, I think that's the way we're going to get to perhaps some kind of an answer.
I was thinking about that.
Go ahead, Nicholas.
I was just thinking about that in terms of wind rights. In Texas, we at least I've seen it done, and I haven't seen this challenge where you can sever out, say, the wind rights over your property and allow somebody else to either reserve those wind rights or sell them to somebody else. But the question is, I'm wondering now, and it's kind of an open question that just occurred to me, is what are you reserving and what are you selling? It's almost more like an easement, because it's exactly like the ability to come on the property and erect that wind turbine. You're not necessarily reserving wind rights. It's not the same as owning a mineral, which you actually own the hydrocarbons that are in place in the ground in situ. It's something completely different, and that may throw a whole nother curveball or put another fly in our ointment that I'm thinking about. I don't know if anybody else has any thoughts about it. Don't allow that to be severed?
Right. There are statutes, I think, in the Dakotas that prohibit severance other than through leasing. I would hope Texas wouldn't do that. We ought to facilitate this industry. But Nicholas is right. We don't have the answer. Is it severable, not severable? Is it incorporeal hereditament, an easement? What is it?
Mm-hmm.
Hey, we're probably going to move to taking some questions from the audience. So before we do that, I'd like each of you to give your best elevator speech about who you think owns it, Mineral, Surface, or someone else. And if you can, combine that. If you're going up in the elevator with a CEO of a geothermal company, and that person, if she asks you, well, who should I execute my lease with, the surface owner, the mineral owner, or both? Take it away. Who owns it, and who should the CEO lease with? Peter, I'll turn it to you first.
Thanks. I think that as we see in renewables, the same debate, non-answer with regard to geothermal. My answer would be one. I think that the lessee ought to go where minerals and the surface have been severed, ought to acquire those lease rights, authorities, and easements from the surface owner. And whether that is a surface attribute or not remains to be seen. But I think I agree with Gabriel and the rest of you that I can't give you a guarantee, but it's, I think, unlikely the legislature or the courts will say it's a mineral. I think they both wish to expand this industry. And in terms of what is it, I think we'll find out what it is, but I think that begs the question again. It goes back to from whom do we, it's almost academic that the real question is from whom do the real world exploiters of these renewable energy systems acquire the authority in order to monetize it. And I would think that would be the surface owner. The way this came about, as far as I'm concerned, is I had a client call, and the evolution of renewables followed the evolution of hydrocarbons, in which not just leasing, which we've seen over the decades, but now financing, collateralizing, factoring, collateralizing income streams from the lessors. And so they said, well, where does the security interest go? What do we do? As Nicholas says, what is it? How are we treating it? And so I think that answer would be from the surface owner. I think you would treat it in the nature of real property, personal property, severable type interest. I think at this point, you're going to have to write it pretty broad. But ultimately, I think the imprimatur for the exploitation of that right would come from the surface owner.
Excellent. Thank you. And you're riding an elevator in a tall building.
Yeah, real tall. Yeah, we're on the way back down.
Gabriel, you want to go, or anyone?
Sure. So my inclination, as I said, is it's not a mineral. It's something unique. And because it's not a mineral, I guess de facto it would, the question goes to the surface estate. But the question is, can you have ownership in it? I'm hesitant to say that you should have ownership. I go back to access, but then it's the surface estate owner who would assign that access. It's because it's not a mineral. So this is not my interpretation of the current law, because the current law doesn't tell us. It's really not helpful. This is sort of my ideal where I think we should go.
Would the surface owner be entitled to a royalty for providing access?
That's part of the access agreement. You can put anything in an access agreement. It's an easement, it's a license, and a royalty. You can absolutely attach that, but that's I don't think they're mutually exclusive.
Nicholas.
Yeah, I agree with that. And you asked if the landowner would be entitled to a royalty. I've tipped my hand. I think it's pretty obvious that I think the surface owner not necessarily owns the heat, which is the product of the process, but owns the ability to grant access to the pore space under the ground, to the native waters, to the native geologic formations that contain hot rocks. And then whatever's created by that is owned by the lessee who creates it. And I forgot my first point that I started out this with whenever I got back to the surface. But yeah, and I would tell the CEO of that company that he should approach the surface owner if the minerals have been severed, and maybe for, to be safe, is get some sort of ratification or some sort of waiver from the mineral owner. That may open a giant can of worms, because if I'm a mineral owner and I have to sign something, I'm like, well, why am I signing this? What am I giving away? Maybe the answer is nothing, but maybe the answer is something, and that's what could create a controversy.
Great. Excellent. Mike.
Yeah, I come at this, I think land where everybody else is landing. I think when I think about it from a legal standpoint, we've got an ambiguous statute, sort of thinking about common and ordinary meaning of the term mineral. If you do launch a search, and I may have missed something, but if you launch a search of the Railroad Commission, the Property Code statute, or the Railroad Commission rules, or the GLO's rules, and you find the term mineral, I don't think you're going to find anything that looks like heat. I think Gabriel's right. It's going to be tangible, organic or inorganic materials. And so I think when you approach this, you go to the surface owner and you try to get very clearly the specific property rights that you need to provide for your ability to have the vehicle to extract that heat. So if you need to inject water, or you need to do, then you get those rights clearly defined from that landowner. I think you would be remiss if you didn't, if they were severed, to not go look at the mineral leases. I'm not advocating that you call the mineral owner and invite that issue, but I would certainly take a long look and see if you think there's an issue that needs to be clarified. So the answer may be both, but I think at the end of the day, the holder of the rights you need to develop your geothermal project lie with the surface owner in the first instance.
Well, thank you. As the moderator, I'm going to take the opportunity to add my 2 cents. I agree with all of you that, and I tend to oversimplify things, but in my opinion, the main test, as you all know, but for the audience, the main test that the Supreme Court has given us to determine whether something belongs to the mineral estate or not is what's called the ordinary and natural meaning test that Mike just mentioned. And it's basically, is the thing in question a mineral under the ordinary and natural meaning of the term mineral? And in my opinion, the answer is no. Heat is not a mineral. Geopressured water is not a mineral, and steam is not a mineral. Therefore, under the bundle of sticks, it still belongs to the surface estate. That being said, as you all mentioned, as a careful attorney, you've got to look at the actual language in the deed records, because they might have something unusual, such as oil, gas, minerals, and other valuable resources. In that case, you got a whole new question. But if you got the normal language, which for the audience in Texas typically is oil, gas, and other minerals, in my opinion, it's not a mineral, so it's with the surface. Thank you all very much for tuning in. Thank you, panelists. Great discussion. Everyone, have a great conference.
Thank you.
Thank you.